For most Indians, owning a home isn't just an investment, it's a lifelong dream. But while the skyline is full of flashy developments and big promises, the ground reality often tells a different story. From fake land titles to stalled projects, hidden costs to misleading ads, real estate scams are evolving as fast as the industry itself. Hi there, I'm Nandita Khemka and you're watching Realty Returns powered by 99acres.com. On the show today, we'll help you spot scams before it's too late. We'll also decode the hidden costs that buyers often tend to miss. And the big question, is RERA truly protecting home buyers or does reality fall short? To break it all down on the show, we'll be joined by Jayesh Rathore, co-founder and director at the Guardian's Real Estate Advisory, and Ketan Mukhija, senior partner at Burgeon Law. But first, a look at what's happening on the ground, how buyers are getting trapped, and the key red flags that you need to watch out for. For many Indians, young and old alike, owning a home or land is a cherished dream. In fact, developers are reporting a rise in young buyers. However, this dream also comes with the risk of real estate scams. Fraudsters are finding new ways to scam people despite stricter regulations like RERA. Legal experts say most frauds involve fake land titles. Scammers use political connections and corrupt officials to illegally transfer land ownership and present themselves as owners. They often target abandoned land, disputed properties, or landowners who live far away. Experts recommend always verifying land titles from the local registrar before buying. A proper legal check can save you from years of trouble. Not just land buyers, even apartment buyers face risks. Some developers misuse EMIs from buyers to purchase new land instead of completing projects. Some even file fake legal disputes to delay handover. To avoid falling victim to a real estate scam, it's crucial to conduct a title search on the property covering at least the past 40 years and thoroughly verify the developer's background before making a purchase. A little research can go a long way in safeguarding your hard-earned money. Clearly, even with regulations in place, home buyers continue to face major risks. Now, how can you avoid these pitfalls and what are your legal rights? To decode all that, we are joined by Jayesh Rathore, co-founder and director at the Guardian's Real Estate Advisory, and Ketan Mukhija, senior partner at Burgeon Law. Gentlemen, thanks a lot for taking our time and joining us here on Realty Returns. It's a pleasure. Jayesh, let me start with you. While demand for real estate is booming and the industry is growing, scams remain alarmingly common. What according to you are the most common misleading tactics that developers and agents use in advertisements? And oftentimes agents and developers present fraudulent documents and offers that are too good to be true. How can buyers really identify these red flags and ensure that they are not falling prey to any such scam?
Thanks, Nandita, for giving this opportunity to share our views. So based on my 25 years of experience, because a couple of cycles which has gone through, and thanks to the RERA, because once the RERA came on the regime, there is a lot of transparency which has came to the real estate sector. At the information perspective is there. It is a buyer's responsibility to go through the RERA websites and get the all information verified. For an example, if the title of the particular plot has been given that as a document, even the legal cases which are going on, the developer has to be declared over there. Now, this kind of transparent information which is available, we as a buyer, because it is a hard-earned money which somebody is going to put it as a most expensive, most emotional sense of achievement, less frequent, which I personally believe that real estate is the most expensive something we'll buy. And for such a purchase, we as a buyer or we advise buyer to go through the RERA website, download the documents, verify that if any cases are there, and have a legal opinion for any legal cases which are there, or ask for the clarification from the developers also as far as the title, because title is something which is to an extent, even sometimes we have observed that buyers doesn't even understand that what is a freehold title and what is a leasehold title. If it is a leasehold title, then what are the consequences after certain years of expiry of the lease getting expired? Now that kind of information is available on the RERA. A buyer has to visit the RERA website, download those informations, and scrutinize the project at the title perspective. Something which you said, the misleading advertisement right now, when you ask me questions, I think advertisement is some historically by developer has always positioned the project as a premium, showing the views which are misleading, showing the view with an artistic impressions, having a different kind of sometimes they show the
Right.
render different view, sometimes they show the lifestyle. The couple, I think I'm still okay with the lifestyle picture because customer can relate to, but showing something which is not there, some misleading views from the window, and especially in the city of Mumbai, when people are buying view because it's a tall building, nobody wants
Right.
to stay on the lower floor and to enjoy the good ventilation and the view. So from a real estate perspective, even for an example, suppose when we write offering and we write asterisks over, sometime when you see the advertisement has always written asterisks over there, those fine prints developer, the buyer
Right,
has
Jayesh.
to ask clarification of and go in the depth of it, the information which is available on the advertisement. So these are my, genuine request to the buyer to utilize the information available on the RERA and do
Sure.
not believe advertisements straightforward directly. Ask many questions as much as possible.
Sure. Jayesh, we'll come back to you. Ketan, a very important point that Jayesh really raised is that, the buyer has to do his due diligence. But do you suggest or would you advise buyers to keep a lawyer for every real estate purchase? Or do you think self-verification is sufficient?
First of all, thank you, Nandita, for having me over. I think, it's a very pertinent question that you've asked. In terms of the legal protection, which is there under the Real Estate Regulation and Development Act, which is the RERA, of course, we often say that, symbolic existence of the law may not suffice. The implementation deficits is something which is very critical, crucial, and imperative. So to answer the question directly, I think, buyers beware, caveat emptor is basically the jurisprudential concept which is already there in law. However, it is always advisable to have a legal opinion. For example, I'll give you the RERA contains all the correct protections which are best practices and the market industrial best practices from across the globe. It contains the protection against title defects, as Jayesh mentioned correctly. It contains a mandatory conveyance of title. It conveys, protection against delayed possession. It also has protection against, false advertisement, which is misleading and based on incorrect information. It also has protection against plan alteration, transparency requirements, fraudulent agents, so on and so forth. The thing is, while the buyers, of course, can take adequate protections, ring fencing, and measures to understand the protections, the as it's always said, the promoters think two steps ahead of the regulation. So I think, it's always better to get a legal advice on what possible gaps, on what possible schisms, and what possible flags can be raised. Because as a buyer, if you see a title document, you may not be able to understand whether it's forged, fraudulent, etc. But what you mentioned earlier, that why don't you get it verified and corroborated from the SRO or the registrar of assurances, etc., that will be very critical. For that,
Sure.
you need expert advice or on the ground advice. So that is always advisable to run a double check of the procedures, of the documents and processes.
So, but if a buyer falls for a fake listing or a misleading ad, Ketan, what is the legal recourse that they have, and how effective do you think the system is in resolving these issues?
Okay, so basically, false advertisement. Firstly, let's understand. I'll break it down into two pieces. What is a false advertisement? And I agree with Jayesh, something which is lifestyle oriented, something which is giving a slightly glorious picture, etc., may not constitute a false advertisement. What constitutes a false advertisement is basically, based on incorrect information. So it's either factually or legally incorrect and misleading. So it amounts to a misrepresentation in terms of the settled law. And the protection there against is contained in section 12 of the RERA, which basically say that home buyers who make payments based on incorrect factual information in advertisements are entitled to a compensation or can withdraw from the project with a full refund plus interest. However, having said that, I'll put a caveat that, getting the compensation, of course, with full refund and interest can be a complicated, nuanced, and protracted kind of an exercise. However, I think, the judiciary is putting in the checks and balances to make it expedited and summary in nature.
Jayesh, coming to you, of course, you said it's the buyer's responsibility to verify everything, but shouldn't the developer also be transparent? That's also leading to a lot of scams, right? And in terms of delayed projects, who should be held really responsible for that? Would you say it's mostly the builder's fault, or should it be blamed on regulatory hurdles? What should buyers really do if their project is delayed indefinitely? What's the next course of action according to you?
I think the main couple of after the RERA came in the picture, there is a framework which is given by RERA that you have to declare what has been approved, and without approval you cannot start selling the property. But okay, let's give an example that why the project used to get delayed before RERA, because developer used to use the proceeding from the sale to buy some other project or to prioritize the construction of the other project which are nearing possession to improve their cash flow. But after the RERA, that 70% has to be used towards the construction of the project. So definitely developer is not going to take out that money to use it for some other project. That practice has been stopped. But another reason where the projects getting delay or may get delay is an approval front, because there are still some project which in my knowledge says that if the building is tall and then developer divides the floor wise RERA, and for example, suppose building is 60 story, then it divide into 20 floors, or 30 floors one RERA, 30 floors other RERA. Now in that situation, consumer has to be well aware. Consumer should scrutinize the project that the floor which is buying does have an approval or not. Does it fall into the same RERA or not? Does any kind of potential threat is there where if the approval doesn't come, then the project get delay. Now, these are the only reason which, according to me, especially the approval related front, consumers should be well aware about for the potential threat of any if the projects get delayed. But as far as the cash flow is concerned, the RERA regulations does not allow the developers to take out the money, utilize the same money for completing the project. Only if the requisite approval is not there, then only the projects is getting delay in the present scenario.
Right. Ketan, legally, what is the first step that a buyer can take if a project is delayed indefinitely?
Let me just take a step back and tell you, and of course, just add to the incremental factors which lead to delay, especially in NCR region, be it Noida, be it Gurgaon. So one, of course, can be a conscious and a deliberate delay. Second could be deviation from approved plans, because if the completed projects may not match the approved designs, which is compromising the amenities or parking, etc. Again, it leads to delay in approvals. And delayed approvals, whether it's utility or a regulatory approval, can really pose an impediment, obstacle, or a hurdle. Coming to protection, Nandita, the protection is contained in section 18 of the RERA, which basically says that, if a promoter fails to deliver the possession in accordance with the agreement, which can be a buyer flat agreement, allottees can either withdraw from the project or claim a full refund with interest and compensation, or remain in the project and claim interest for every month of delay. And this remedy, I want to highlight this with emphasis applied, is available without a prejudice to any other remedy available. So basically, if there is a fraudulent misrepresentation based on which, the buyer has put in its hard-earned monies, there could be a criminal recourse. Of course, that is, of course, within the four confines of the law. However, it depends on the kind of spurring factor or the trigger by which, the money was paid to the buyer. There is a protection. So just to summarize, there is a protection under RERA, under section 18 specifically. However, it depends on the buyer to take the recourse one way or another and to expedite that to his benefit and to gain the requisite outcome.
Okay, Jayesh, let's also talk about the financial stability of the developers. How can home buyers really verify if a developer is financially stable and not misusing incoming funds? Because there have been cases in the past where developers have used EMIs for under construction apartments to buy new lands and neglect the completion of the existing projects. There have been instances. So how should one safeguard themselves from a scenario like this?
So in this case, Nandita, the most of the projects which we are working at present has been funded by the financial institutions. So, there is a financial closure for the project. So in this scenario, there is zero chance that developer is allowed to take out the fund from the receivable and to utilize for some other project or to complete the other activities. First was that. Secondly, for every completion activity, when developer raise the demand to the buyer, they have to produce the certificate which will certified by the engineer, by the chartered accountant, and by the architect for the completion of that particular activity, which can be also verified by the buyer to physically examine in case there is a possibility for them to visit the project and say that okay, this project, or maybe ask for any kind of proof by way of the pictorial presentation of that activity and make the payment accordingly. Other than that, I don't think so there is any reason where or any kind of case which I came across where after the RERA developer has utilized the fund for completing the other activity and not been, because RERA is very strict in terms of utilization of the fund is concerned, and use those proceeding or receivable towards the completion of the project only. But yes, as a buyer, once you receive the demand letter, it is our responsibility also to check the completion of the activity, to scrutinize the demand which has been received by way of examining the completion certificate which is attached with the demand. No demand should be received or no demand should be made payment without checking the certificate from architect, chartered accountant, and engineer that okay, so much cost is incurred, this is particular completed, etc., etc.
But just tell me one thing. Do you think RERA has genuinely improved transparency, or are there still loopholes that developers continue to exploit? Because if there wasn't any loophole, there wouldn't be so many scams. So what are your thoughts on that?
No, I totally agree with you that RERA has given a framework to define. For an example, I'll tell you, suppose there is a building which is 70 meter, which is no HRC, and say 22 floors, and three basements are there. Now, if you ask any contracting firm or you ask most of the reputed developer, they may say that such structure can completed within a very in an expedited manner, say in 2.5 years, or maybe by delay or by a little bit of relaxed construction, max 3 to 3.5 years. But if any developer is putting completion date of such project by say 5 years or 6 years, because RERA is saying what you define how much time you complete the project and you have to complete within that project within that time frame. But if any developer whose intention is not there to complete the project on time or in the expedite manner or in the required time frame which otherwise 22-story building can take, he or that kind of developer will definitely put the buffer of 1 or 2 years with intentional. It is buyer's responsibility also to ask this question or to compare that in that micro market, if 22-story building is completed by XYZ developer on an average 3 to 3.5 years, why a particular developer saying I will take 5 years? Because there is an intentional issue. Now that is buyer duty also to read this information from the RERA, use the logic that why such 5 year has been set. Is there any approval issue? Is the approval is not received? Is there any IOD is received for certain floor but CC is not received for certain floor? Because sometime developer delay the payment of the premium to buy the premium FSI, which is linked with the construction status also. Because okay, example, if the building is 70 meter and 22-story, then developer can buy the entire FSI by there is a base FSI, there is a TDR, there is a fungible FSI. But to make the payment of the fungible FSI today, time of launch, developers sometimes don't buy that FSI, but because IOD is received, they start selling it. But for some reason, if the project is got maybe I mean, there are reasons which are beyond even developer intention too. But if
Jayesh, we are a little short on time. I also want to get in Ketan's thoughts on this. Ketan, what should be the next course of action in case RERA fails to resolve a buyer's complaint? What legal recourse can a buyer take then?
Sure. So, Nandita, in this case, I'll again, take a step back and then, of course, talk about the funds and then come to the, recourse which is available to the retail buyer. Basically, there have been a lot of real life examples. I won't name them, but of course, the places like Bangalore, Gurgaon, etc., wherein the fund was received either from cell phone funds or from the flat buyers or from financial institutions, but they were actually misused, diverted, and fraudulently mismanaged. In that case, what do you do? Of course, as a lawyer, I have dealt with a lot of financing and security documentation. There is a utilization of proceeds clause, but who monitors it, who surveils it, who actually tracks it down is anybody's guess. So those diversions and digressions in the usage of funds is a major problem, and that I think buyer has very limited and restricted control on. Having stated that, I'll come to the question that of course you asked, that specifically in terms of what recourse and remedy is available to the flat buyer in case there is a delay or an inordinate delay of the project. Then, as I mentioned earlier, if there is a delay in this possession, then what happens is RERA section 18 comes into play. He can so bas- so basically, he can either withdraw from the project and claim a full refund with interest and compensation, or remain in the project and claim interest for every month of delay. However, the question is, how enforceable. So again, I'm supplying a lot of emphasis on this.
Yeah.
The throttle is on the fact that, Nandita, how effective, efficacious, and suitable the remedy is. Do you think that, if the flat is getting delayed, you go to the builder and file a case and it'll be resolved? The answer is, it takes a lot of hurdles, impediments, and obstacles to cross. So the buyer does not have an efficient remedy as of now, although the law says that. However, to practically realize that becomes a challenge. And therefore, the state of affairs is what it is. The predicament or the conundrum is what it is, you mentioned.
Just want to come to Jayesh. One question before we wrap. Jayesh, what are the common hidden or unexpected charges that buyers face that they often tend to overlook? And can these be renegotiated and reduced? Very, crisp answer. That's what I'm looking for here.
No, very straight. I think agreement value is always base rate, car park, and the floor rise. But any other charges which usually, sometimes the cost sheet mentioned to the society charges, like a development charges, infrastructure charges, there are, the clubhouse membership charges, etc., which develop buyer should be well aware of and ask that, okay, this is the total cost which I will be paying it to the developer, and the same is getting documented in the agreement, and not anything over and above this which buyer will be paying it for. But at the time of inquiry also, whether it is telephonic, whether it is a personal inquiry, signing of the document, cost sheet and agreement, it is buyer who have to verify not only the agreement value, but stamp duty, GST, the government charges which is going to the government, and the hidden charges are usually being mentioned as a part of the society charges, which buyer should go tight head by head and ask the clarification and say that nothing beyond this will be mentioned in the agreement and he is liable to.
Jayesh, to sum it up, what are the smartest steps home buyers can take to ensure they are making a clean, risk-free investment? Very quickly, 3 to 4 pointers that buyers should keep in mind.
The buyer should read the RERA, I mean, not just a number, but go to the RERA website and download all the forms which you mentioned, all the documents which are there, and ask questions. Because I always say to my buyer that when you make the inquiry, there is always, do not get carried away with the advertisement, which otherwise portray the larger than the the light effect of the project. Ask as much as questions possible, and especially at the approval front. So the first I will say read, secondly is ask, and third is, which I said, that don't get carried away with the advertisement, but ask as much as questions, especially related to the approvals.
Sure. Ketan, must have legal documents to verify before purchasing property?
Sure. So again, to give you a crisp answer, threefold. Number one, that the devil lies in the detail. So if you are given a lot of documents, please ensure that you are going through the stipulations and the consequences of non-fulfillment of those stipulations very carefully. Number one. Number two, whatever assurances you are getting, get them in writing, because obviously there's no record or there is no admissibility of verbal. It's very difficult to prove verbal assurances. And number three is, of course, check the builder's track record. So if you can get a personal recommendation, if you can and obviously, don't haste into, a project because somebody says that, look, this is a scheme which is a timely scheme. You act with promptitude and then you'll get the benefit. Do not do that. Read the documents, get the documents. Of course, they are bulky, but please ensure that, whatever you're not comfortable with, you go back and,
Sure.
as Jay said, ask the relevant questions, so that, the JP episode, for example,
Sure.
since it's all over the news, does not happen. The company goes into insolvency, and then, after years and years and years of
Yeah.
fighting the case in the legal battle, it's still not resolved.
Sure, which is why we are bringing this show to our viewers so that they can do their due diligence. They should know what to do in case they have fallen prey to some bit of scam, or if there has been a delay in the project as well. But with that, gentlemen, would like to thank you for taking our time and putting things into perspective for us. Pleasure chatting with you guys this afternoon. That's what the expert take is. Of course, do your due diligence, ask the right questions, and very important, take everything in writing, and of course keep a lawyer with you when you are before making any real estate purchases. But of course, before we end the show, are you planning to invest in real estate? Scan the QR code now and explore top properties with 99 acres. Well, with that, it's a wrap on this edition of Realty Returns. We'd love to hear from you. Share your thoughts in the comments and tell us what topics you'd like us to cover next. Thanks for watching, and we'll see you next week. Take care and goodbye.